Well, good afternoon, everyone. Thank you so much for joining the Delaware SHRM legal webinar. I'm honored to be able to present to you two colleagues of mine from Richards, Layton, and Finger. I will read their bios and then we will be getting started. Jennifer Giuffre and Lori Brewington are attorneys at Richards, Layton, and Finger, Delaware's largest law firm. Award-winning employment lawyers, they represent a wide variety of business clients in their labor and employment matters in Delaware and neighboring states. Jennifer and Lori provide customized solutions and practical legal advice to the many issues that arise in workplace relationships. Jennifer heads Richards Layton Labor and Employment Group. She has been recognized in Chambers USA, the Best Lawyers of America, Benchmark Litigation, Super Lawyers, and Delaware Today, where she was one of the state's top voter getter in labor and employment law. Committed to pro bono work in the community, Jennifer leads the firm's Guardian ad litem team, which represents children in abuse and neglect proceedings, and is the past chair of the board of directors at Catholic Charities of the Diocese of Wilmington. Mother of 5 children, Jennifer also coaches middle school basketball at Ursuline Academy. Lori's employment law practice is enhanced by her background as a human resources professional, experience that has given her added insight into the issues her clients face. Lori has been named in Chambers USA, Super Lawyers, the Lawyers of Color Hot List, and Delaware Today, where she is listed as the 2019 top vote getter in labor and employment law, and featured in the magazine's Hottest Topics on the State's Legal Scene article. Lori devotes many hours to pro bono work, and she serves on the boards of the Children's Advocacy Center of Delaware and Action for Delaware's Children. A Delaware native, Lori has a 3-year-old daughter. I would like to present to you at this time, Lori and Jen. Thank you.
Good afternoon, everyone. Hi, this is Jennifer Giuffre, and although I cannot see all of you, I'm so excited to be here with you. Lori is as well. I'm just checking my volume. I see a note that someone says the volume may not. Before we begin, well, first, as I was saying, Lori and I are so excited to be here with you in this format. We do have an agenda, and I will go over that in a second. But as you may recall, if you've ever attended any of our prior presentations, we like to do a quick brain teaser, just something exciting or something that caught our attention in the legal news, and pose it to you all to get you thinking, to get our brains awake for this seminar. So can the EOC, or how this came about? And before we get into the answer of whether they can or whether it's a valid claim or not, let's hear what the claimant actually claimed here, what she alleged. Ms. Menachem sued the EEOC, and you'll see it's versus Dillon, Janet Dillon. She is the chair of the EEOC. And this woman claimed, dating back to 1994, this is an old case, although the appeal just came down here in 2020, so it has new relevance for sure. But the allegations go all the way back to 1994, when she began filing anti-discrimination and retaliation cases against the other federal agencies that she saw issues with. She believes then that the EEOC started treating her differently because of that. She became very stressed with this mistreatment. She claims post-traumatic stress disorder. She asked for an accommodation, which the EEOC thought was an indefinite leave of absence and denied, and things got worse. So then in 2013, she started to allege issues with her pay. She was on a paid leave. She alleged problems with both her wages and her benefits. That eventually went to the district court, where she was suing for hostile work environment and disability claims. She also had some interference claims against a federal act. But basically, it's similar enough in the sense that she was filing Title VII claims as well that you all can relate to. So how do you think the court ruled? Is the EEOC a proper party? Does the EEOC face liability here? Well, you'll see that the EEOC initially won. The district court said that claims that the EEOC mishandled payroll and healthcare were not severe or pervasive enough under our hostile work environment standard. And so the case was dismissed. The case was also dismissed on the failure to accommodate claim. It was an indefinite leave of absence and on other issues. The DC Circuit then reversed. This is what happened in 2020. And it's striking because there they said, not only can the EEOC be a proper party, the EEOC is an employer, and the district court didn't find otherwise. EEOC is a party, or is an employer, they have to follow federal laws. And it said that the deliberate attempt to affect an employee's finances and access to healthcare are precisely the type of conduct that might dissuade a reasonable worker from making or supporting a charge of discrimination. You may recall that's the standard that came out of Burlington a while back. It's been some time now, but that really enlarged our standard for retaliation. And for some time, it was thought that certain things outside the actual place of work may not be included. Here, this person was on a leave when these things were happening, but she alleged that the HR and her manager were both involved in acts that prevented her timesheets from being approved, that caused her healthcare insurance to lapse, etc. So they thought that because it affected her finances and access to healthcare and benefits, that it was falling within the possible claim of retaliation. So it'll go back to the district court. The case will proceed. That was on a motion to dismiss. So potentially there'll be discovery and a trial down the line. But it is interesting to note that the EEOC can also be sued for harassment, even though it's charged with being our model employer and should not get into these issues, but it's still comprised of people that make mistakes. So moving forward, let's talk about the agenda. I won't go into detail. You'll see on the next several slides that we have 5 hot topics, and we had to narrow it down to 5. As you know from past presentations, we usually try to give a full array of all of the updates from all the various federal employment agencies, as well as our state agencies. Statistics, data, new laws, everything. We really tried to get it all to you, but in an hour, we really thought that was not possible. So we tried to boil it down to the top 5. Some will take us a few minutes longer, but we really intend to go through all of them and not get unnecessarily bogged down in each or in any one topic. As you see, we'll start with COVID, then we'll transition to the Supreme Court stance on transgender and sexual orientation issues. Then we'll talk very briefly this recent year, but we're going to focus on 2 of their topics and some things with reminders regarding to the DOL, as well as some new things that came out of the Department of Labor in regards to the FLSA. And then we'll end with some new and proposed legislation out of federal law in both our Delaware state. Lori and I will be switching back and forth. So the first topic is COVID, and you may all be sick of COVID. You may all know more about COVID and the employment regulations resulting from it than you ever thought possible. You learned them quickly, as we did, on the fly. And so I'm not going to spend too much time on the basics because I feel like we've already had to have learned these to get to the point we are in time. But I will touch on a few topics just to make sure we're aware of them and we're not applying them incorrectly, or to talk about some things that have been clarified recently by these agencies. And Lori and I will be splitting this topic, so you'll hear from Lori in a moment. First, we want to talk about that there are lawsuits. Lawsuits are definitely happening from employees who have been exposed or have COVID-19. And so let's talk first quickly. There's 3 of them to talk about. There's Safeway. And here, this was a memo that was posted at the workplace called Coronavirus Risk, Fact versus Fiction. If you are healthy, a mask will not protect you. Open areas of the mask can let those drops in. A wife's husband who worked in the Safeway distribution center died from COVID, and she sued Safeway. She claims that it was not a safe work environment. They failed to follow OSHA guidelines and guidance for sick workers to be isolated. And most importantly, I think to tie in that memo was it misled the workers that claimed that wearing masks wouldn't protect them from the coronavirus. So when I read the memo first, I had to keep thinking about it to really get the point. But basically they were saying that there's no need to wear those masks. It's not going to help anyway. So the defense cases happened, not recommended. And they had had an inspection of the facility by state officials on April 15th, at or near the time of the death, and there are no violations of the COVID-19 guidelines that existed at that time. So I don't know if those same defenses would apply to a newer case, but it's interesting to see how that case will develop. Then we have Walmart. In that case, it was a bit different. These are alleged allegations where this individual, a store employee, told his manager he was not feeling sick. The symptoms were that he relayed to his manager were COVID-19 type symptoms, and his manager just kept him working. In other words, he said, just put him back to work. Well, I'm not sure who knew the exact words, because that employee was found dead in his home 2 days later. His symptoms had worsened. The employee was eventually sent home and then was found dead. Employee's family claims that Walmart didn't follow the pertinent guidelines, putting the employee at risk. And then meanwhile, another employee at a Walmart store did survive, but alleges that Walmart was failing to provide the personal protective equipment needed to protect against the virus spread. So Walmart's response is, we are taking every step that we're supposed to. We're following all the guidance as it comes out. It's impossible to figure out where or how someone contracted the coronavirus. And that will probably be the employer's biggest defense in these types of cases, that you can't prove that you got the virus from us. However, when the employer fails to take reasonable steps, such as an employee complaining about symptoms and then sending him back to work, that may be different in light of the guidance. So we shall see how that case develops. Again, they're just allegations at this stage. And then we have a third case here. That's a Tyson case. 3 employees in Iowa died at the pork processing plant. They claim the outbreak occurred at the plant, but Tyson neglected to shut the plant down against recommendations of local health officials. Tyson denies the allegations. It may come down to whether that was a required closure versus a recommended closure, and whether a reasonable person should have shut that down, but we shall see. We just wanted to give you a little bit flavor of what's going on. I think ultimately the biggest thing to know is that there are mitigation measures to decrease these risks of liability. And then the same types of mitigation measures we would use at any other time with other employment issues. Again, we're gonna make sure all our policies are up to date. We're gonna train, and we're gonna communicate. We're gonna make sure we investigate, document. We're gonna make sure we have plans in place. We know how to deal with it. The people that are going to deal with it, they actually know the law. They know how to respond, so that your managers, if they're hearing the complaints, if it's HR, whoever it is, knows the law. So generally simple, but yet it takes time. As we could see during this pandemic, we were helping clients with plans, memos, communications, policies, changes, revisions, etc. And it does take time to try to get it right, as well as to be aware of the changes that are constantly coming down from federal and state agencies and government orders, to be sure you're trying to take it all and doing the best you can with that. So moving forward, let's talk about Family First Act. Bit of that. This is a piece I feel like most of you know at this point, because you've already probably had to apply it, although some of the school closure issues starting the new school year may have become more pertinent again. But basically, you know, this act came about and we had to learn it so quickly, in fact, that I think for about 2 or 3 months, I called it the Families First Coronavirus Relief Act, and not the Response Act, because we were just in survival mode, trying to handle all our regular work, plus learn this new law and respond to clients. But fortunately, that was not a fatal mistake. Anyway, this act will still be in effect until the end of the year. And it applies, as you probably well know, to employers with fewer than 500 employees. And that's every employee on your payroll, or even those that are inactive but are generally your employees. So you can't say someone's on leave and not count them. For instance, the only people you're excluding are true independent contractors. As you may know, there's certain reasons that you can take the paid sick leave. That's the first 2 weeks, or that's the 80 hours we should think. It's 2 weeks of leave. It's the first thing you usually look for when someone is asking for some sort of COVID relief. First, do they meet this sick paid leave? And it's going to be, are they sick? Are they under a quarantine? Are they caring for someone that's subject to a quarantine? Are they caring for a child whose school is closed, or whose regular provider, even a babysitter, is unavailable? as you probably saw, that it could apply to way more than just physical school buildings being closed. And then there was a final issue about any other substantially similar condition. Although I checked again recently, and that still has not been regulated or defined. So we can basically exclude that last one because there is no other condition as of now. The paid sick leave has dollar amounts, certain reasons. When you're sick or you need to be quarantined, you're going to get more per day than if you're caring for someone else or if it's a child care issue. And eligible employees are reimbursed by the federal government through refundable tax credits. And you should look to the IRS to take care of that. There also are documentation requirements in order to get that, as you probably know. So here's another question. In regards to the Families First Coronavirus Response Act, what if an employee is not sick and can work from home? Are they able to take paid leave, the paid sick leave? Generally, no. If they're able to work from home, they would not be taking this as paid leave because they can work from home. If they are able to work from home generally, but because they're taking care of someone else that prevents them from working from home, that would be different. Physically caring for a person. Someone that's just in quarantine does not need care typically, but someone that has experienced symptoms may need care. And if they're the person providing the care, then that may be different. But you should also consider, as we had to for cases, to make sure that person can't work off hours or to be able to still work and provide the care. But ultimately, it is the right of the employee. So we're not trying to interfere with that right, but we're just making sure that it's being used appropriately. So once you get past that analysis of whether or not they were part of the paid sick leave, then or you may have heard about the expanded FMLA, which is different than regular FMLA because it's paid and it's for a very specific reason, but it still counts as part of those 12 weeks of leave. So this emergency leave is always at 2/3, and it's week 3 through 12 for those who have already taken paid sick leave for the care of a child. But if they didn't take it for the care of the child, then because of the school closure, then it could potentially be 12 weeks. If they've not used any sick time yet, they could potentially have 12 weeks for the care of the child. So you'll see the cap at the bottom here in terms of dollar amount. This is for 10 weeks. 10 weeks is capped at $10,000 total. But if they had coupled with the first 2 weeks under the paid sick leave, it would be a $12,000 cap. These are for the employees, although the first part was for new employees, could be involved as well. Employees here had to have been employed for at least 30 days in order for this to happen. The first 10 days couldn't conceivably be unpaid, but we found that most people were already using the first 10 days as paid through the paid sick leave portion because they met those eligibility requirements. But you'd have to take it step by step to make sure you're not expanding the relief required. If you already provide sick leave to your employees and provided it before the act went in effect, you provided that and you were not allowed to take a credit for that paid time. You gave that prior paid time, then you provided this benefit, and then any remaining paid time left, they still are eligible for. Moving forward then, we're looking at making sure you have the notice. I hope all the notices went out. The notices do not need to be translated, do not need to be done in multiple languages, but the DOL is working to get that translated. And you must post the notice in different work locations if the employees aren't regularly going to each location. So I think it's just best to make sure each location has this notice. I think it's also important with so many remote workers right now to be sending it out to everyone who has email access. Hopefully you've already done that, and any new employee must get a notice of this rights upon coming to work. Okay, so the revisions to the FFCRA that came out recently, we're just clarifying certain issues. You may have heard about this, it made some news. I think the biggest one probably was important because of schools starting back or the uncertainty of whether schools were going to start back and in what fashion. And looking at the updated guidance, it was important to see that if a child attends a school that's operating on an alternate day basis, that's not intermittent leave. No approval is needed from the employer. They would qualify because each day of school is its own separate reason. So any type of odd in-person at-home arrangements the school may have set up that may just not be a full week at a time, they still are allowed to be at home, eligible for this leave when they need to take care of that child who's no longer at school. And they said the school is closed when the physical building's not open. If you have the option to either do in-person or at home, and you choose to do at home, you're not going to be eligible. But fortunately, they issued a clarifying question in this regard, that if the person has underlying health issues, that child, that student has underlying health issues, then you may be eligible to take that paid leave to care for that child. So if you've been advised by the healthcare provider to self-isolate or self-quarantine, then you may be eligible to take that paid leave, which is different than just choosing because of general concerns about safety. Okay, and then there was some more updated guidance that you'll see in there that I won't go through, but about the narrowing the definition of a healthcare provider and requiring the documentation to be as soon as practicable. We also know about our employee sanctioned testing and practice, being consistent with the ADA. You are allowed to ask all employees entering the workplace if they've been diagnosed or tested. That's perfectly fine. Make sure you're observing all your infection control practices. Then, as you know, the EEOC issues technical assistant questions from time to time, and they have many, many questions, but I pulled a few out just to make sure you're really focusing here on some question that may not come up or you may not have thought about in detail. So one of them is, can a manager ask only one employee as opposed to asking all employees questions designed to determine if she has COVID, or require that this employee alone have her temperature taken or undergo screening? And the answer is yes, if the employer has a reasonable belief based on objective evidence. So you consider the reasons such as a display of COVID-19 symptoms, but you can be particular. So this does not need to be equal treatment. It just has to be reasonable belief based on objective evidence. So one size may not fit all, but we want to make sure whoever's doing this and asking these questions really understands the law and knows what they're doing. But generally, managers asking about COVID-19 symptoms is the norm. As we all know, any type of activity we do, anything we do, we're filling out questionnaires almost daily for our children, for ourselves, to attend anything, and to go into any on-site work. Okay, so looking ahead, the next question, can an employer ask an employee who's physically coming into the workplace whether they have family members who have COVID-19 or symptoms associated with that? And that's important to know. You cannot ask questions under GINA about family members. However, you can ask the same question, just said, have you had contact with anyone? And I think that's what most questionnaires are designed to do, most forms that you're probably already using, but just double check that it says anyone. I know of one client that's asked anyone in the household, and I opined that I thought that was fine because it was not limited to family members. It was anyone that they are living with or in close proximity with. So I thought that was fine to use in the same household. I didn't feel that was a problem.
Jen, can I ask you a question since we're on
Sure.
this topic? Someone typed in, they are an employer over 500, but they are tracking any leaves, because if they go under 500, then they must abide by this act. Is that correct?
If they go under 500, they will have to abide by the act, but I don't believe they get credit for time they've already provided. The moment you become an eligible employer, that's when the 2 weeks would kick in. So you can't take a retroactive credit, is my understanding. Does that answer?
Okay. Thank you for answering. I think that will answer her question.
Okay, thank you. And then the final question was about when you return from a pandemic, must you wait for that? I'm sorry, from travel during a pandemic, must you wait for that person to develop symptoms to ask questions where that person has traveled? And no, you can ask questions about travel. That is not a disability inquiry, they have said. And at times, if there are certain locations that are on lists by the CDC or other officials, you can even ask about that. So it doesn't matter if the travel was personal or for business, you're allowed to ask about travel related inquiries, which is good to know. So with that said, I know I did skip one of the questions about whether an employer can ask an employee why she or he has been absent from work, and the answer was there, but yes, you are always allowed to ask why someone was absent from work. So now I'm going to turn it over to COVID-19 accommodations and the discrimination and OSHA piece to Lori. Thank you.
Hello, everyone. Just wanted to touch upon accommodations really quick. Employers should ask employees about accommodations needed before returning to the workplace. Conversations around accommodations should be interactive, and I think we all know that from the ADA. It's just a reminder of the guidance that we need to kind of go into this COVID with the same discussions and the interactive process that we use for the ADA. The employers can send a general notice regarding who to contact to request accommodations. That way you can funnel these into a specific person in human resources. You can include in the notices a list of all your CDC listed medical conditions placing individuals at a high risk of developing COVID. And whoever's designated to receive the special request should be knowledgeable. So we want to make sure we train those specific individuals. Employees can request alternative methods of COVID screening due to certain medical conditions, and that's okay. We do have to remember also flexibility provided to caregivers and family members need to be uniform across the board. So we can't just allow our women to have accommodations versus our men. Everybody should be treated equally. So the EEOC also included some guidance as it relates to the Age Discrimination and Employment Act, because as we all know, COVID-19 hits our older population of 65 and older harder than others. And so the EEOC wanted us to be reminded that we cannot discriminate against individuals that are 40 and over. Specifically, the EEOC noted that we can't tell our older individuals that are at higher risk of COVID, those 65 and older, that they can't come into work. That's not going to fly. But we can give them the voluntary choice if we limit it to 65 and older, and that's not discrimination against those individuals that are 40 to age 64. So we can give those that are 65 and older that voluntary option to work from home. That's okay. As it relates to pregnancy, the EEOC just wants us to be reminded that we can provide and must provide accommodations to our pregnant individuals, but we cannot force them to take an involuntary leave, to take layoffs, or be furloughed. Just remember, with our pregnant individuals, they may require an accommodation related to an underlying medical condition and COVID. Employees are not required to provide special accommodations to those that have family members who are at high risk. I think that comes up, and I've had that experience. But you can if you want to. But the issue there is that you have to remember that you have to apply those accommodations uniformly across the board. You can't just allow your mothers who have young children versus or certain people that are staying with older adults. You'd have to apply that uniformly as well. The EEOC has also highlighted concerns about discrimination towards Asian employees. We need to make sure going into this and as we bring our employees back to work, that our managers are up to date on what harassment is and what creates a hostile work environment. And this, the EEOC says, includes comments about the origins or the general circumstances surrounding COVID. So we want to make sure we train our managers about that. We want to make our workforce known and reminded, of course, that harassment and discrimination will not be tolerated. And that includes harassment that is offline. So through social media, I mean, because a lot of us are teleworking, through teleworking, any other form of remote workplace interactions, employees need to be reminded that your policy of anti-discrimination and harassment also applies there. So turning to the Department of Labor's OSHA guidance, they've come out with guidance on COVID. So it's interesting because when I first created this slide, it was in April. The guidance was completely different than the guidance in May. And so let's just focus on the guidance that came out in May. OSHA has issued a requirement that employers with more than 10 employees must record cases of COVID if it's a confirmed case of COVID. If it's work-related, and I'm sure you're thinking, how do we figure out if it's work-related? Well, I'll give you some insight on that. and it involves one or more general reporting criteria. That general reporting criteria is if it results in a death, missing time off from work, restrictions from work, and also note that if an individual is a confirmed case of COVID and it's work-related, it may not involve one or more of the general reporting criteria because they may not need to miss actual work. They may actually be working from home. So that would not be necessarily a recordable event. If they continue to work, they don't seek treatment. So that's something to consider. So back to that work-relatedness piece, the EEOC, the OSHA has tried to provide some guidance on that. An incident of COVID is work-related if the event or exposure in the work environment caused or contributed to the resulting condition. So the OSHA is going to ask you as the employer a couple of questions to determine if you made the right determination in terms of the work-relatedness. So they're going to look at whether it's more likely than not that the individual developed COVID at work. And they're going to look at 3 factors. The first one is the reasonableness of the employer's investigation. And OSHA provided a little bit of insight on that. And they said that's simply, we understand that you need to have some, that employees are going to need to have some privacy. But as an employer, you can ask the employee, where do you believe that you got COVID from? And you also need to consider the information that you have available to you. That's that second prong, evidence available. What exactly was the employee's job duties? Were they exposed to the public? That would put them at an increased risk of developing COVID. Evidence that COVID-19 illness was contracted at work. Here are some of the signs that the OSHA says that there may be evidence that COVID-19 illness was contracted at work. One is lengthy exposure to someone at work that has COVID. Another one is if there are several cases of COVID at work. And the final one is close exposure to the general public. So if any of those things have occurred, the OSHA is saying that it's more likely than not that the person developed the COVID at work. OSHA wants us as employers to take a reasonable and good faith inquiry of this. Reporting COVID cases. So employers, you have to report certain COVID cases to OSHA. Fatalities must be reported within 8 hours of learning that an employer died within 30 days of a work-related COVID-19 case. Inpatient hospitalizations also have to be reported. They have to be reported within 24 hours of an employee hospitalization with COVID-19 infection occurring within 24 hours of exposure, if the exposure occurred at work. And these are incidents of exposure at work. So not just hearing that your employee died of COVID, you have to believe that that employee was exposed to the COVID at work. So turning gears, let's talk a little bit about the US Supreme Court's transgender and sexual orientation protection. This was a huge case. This is actually an issue that Jen and I have talked about for like years, and it's finally been decided. So it's kind of exciting that there's been finally a decision on it, and that happened this summer. Just to remind you guys a little bit of some of the facts of certain of the cases. So the EEOC versus RG Harris, that was a funeral director. Her name is Amy. She had worked at the funeral home for about 30 years. I think all her life she thought that she was transgender, but she didn't really come out. And then 2 weeks after telling her boss, the owner of the funeral home, that she was transgender, she was fired. Similar in Altitude Express, this was a skydiver, a gay male who wanted to make one of the customers feel comfortable because she was going to be attached to him. And he says, you know, just listen, I'm gay, you know, just innocently just said, I'm gay, you're fine. Well, the customer's boyfriend was somehow offended by that. he was accused of misconduct, inappropriate touching, and he ended up being fired. He believes that it was because of his sexual orientation. He filed suit, and all these cases were combined. The unfortunate thing about that skydiver, as I looked up on this case, he actually died in a skydiving accident. So he wasn't around to see the outcome of the case. But hopefully we all know how the court ruled in this case. And it was a 6-3 majority opinion by Justice Gorsuch. And in essence, it said that sexual orientation discrimination and transgender discrimination is sex discrimination under Title VII. Now, that doesn't do much for us in terms of Delaware law, because as you guys all know, we have included sexual orientation and gender identity discrimination in our protected classes. But for those employers in other states or those employers that have individuals working in other states, you want to make sure that your policies and your handbook is consistent with the law of the land as of now. So turning gears to age discrimination. Now this case has little precedence to us in the private sector, but we thought it was interesting because it was a Supreme Court case and it relates specifically to the federal sector. So Babb, B-A-B-B, is a pharmacist for the Department of Veteran Affairs, and she alleged discrimination based on age. She thought age was a factor in the denial of her promotions because the supervisors made a variety of age-related comments. So her argument and her position is that it was a factor in her lack of promotion. And some of the comments that were made is that the supervisor asked her, "When do you plan on retiring?" Another supervisor referred to Magic Mike, the movie, as a middle-aged woman movie while speaking to her. And so that she thought was a hostile work environment. And the same supervisor referred to her as a mau-mau, which she interpreted as a grandma comment. And I had never heard that. I don't know if some of you out there have heard that mau-mau. I looked it up and it didn't like jump out at me as like a grandma comment, but whatever. So she was offended by those things. And she said that those things, those age-related comments coupled with, I guess, other things were the reason why she didn't get the promotion. Now, the issue on appeal is whether she was required to prove that age was the but-for cause of the denial of a promotion. So essentially the only reason for it. So but for her age, which is a higher standard, which is actually the standard in the private sector that we have to show. But for her age, she was denied the promotion. I'll tell you the result of that, so keep that in mind. But one of the highlights of this is that I guess it was hilarious at the Supreme Court that they busted out laughing because Chief Justice Roberts said, let's say in the course of the weeks-long process, there's one comment about age. The hiring person is younger and says, "Okay, boomer," wants the applicant, wants to the applicant. So "okay, boomer" is a phrase that Gen Z, and that's ages 5 to 24 years old, a comment that they make about the baby boomer generation. Okay, so back to the case. So how do you think the court ruled? Did she win in terms of, was she able to show that the fact that age played some small part in her lack of promotion, or did she have to prove that it was the only reason for? So she actually won in terms of the court rejected a blanket but-for causation requirement. But that's, like I said, only for federal age discrimination cases. However, if she wants relief in terms of reinstatement or damages as a result of age discrimination, she is going to have to show that age, but for her age discrimination, she would have received the promotion. If she wants to kind of show that age was a part of it, like a motivating factor, or age had some small piece of it, she would be entitled to something like injunctive relief, meaning that would stop the age discrimination or attorney's fees or something like that. So there's a higher standard for age discrimination cases in the private sector. The federal sector, it's if age has anything to do with the reasoning. So pregnancy and the ADA. Connections, CSP, they were forced to pay $500,000. This is a reminder to all of us about those rigid FMLA, ADA cases, policies that say that you have to come back to work once your 12 weeks of FMLA expires. Make sure that none of your policies say that, because the EEOC views that as failing to consider the ADA and failing to consider whether you can provide them a reasonable accommodation to allow them to return to work. And so the EEOC ended up filing suit against Connections Academy or Connections CSP, and they had to pay $500 in addition to a revision of their policies and training for their supervisors. Turning gears, the NLRB stands on confidentiality in workplace investigations and non-business use of emails. So this is interesting because as I recall, Jen and I, we talked about these topics years ago. And with regard to the first one, confidentiality in workplace investigations, it was in around 2015. And the rule was that we cannot require our employees to maintain confidentiality in investigations because it interrupted their protected concerted activity under Section 7. Well, in this Apogee Retail LLC case, the board made clear that it's important for our employers to be able to require confidentiality in open pending investigations. In essence, the benefit of having these requiring confidentiality is outweighs the rights under Section 7 and concerted activity. Some of the benefits that the board highlighted was preserving the integrity of the investigation, preserving evidence, allowing employees to feel free to come forward without the fear of retaliation. Plus, the board said this is not to say that these same employees can't discuss the discipline that actually comes out as a result of it or the infraction that they were actually accused of. They just can't discuss the interviews. The next thing, prohibited non-business use of work email. I think we all recall this one too. This was a couple of years ago too, where we actually told you guys that you can't prohibit employees from using your work email for non-business reasons. Well, this case came out, Caesars Entertainment, and said the exact opposite. So now employees don't have a statutory right to use an employer's equipment, including work emails and IT resources. The court in that case, or the board, basically said, employees, you can talk in other means. You don't have a right to use the employer's work email. You guys can talk face-to-face, you can talk on social media, you can talk through personal email. So the rule has changed so you guys can review your policies and handbooks to see if it's consistent with the new NLRB rules on this issue. And now I'll turn it back over to Jen.
Hello again. Let's talk about the DOL issues, new and proposed rules on certain items under the FLSA. The first two aren't necessarily that new at this point, but let's just make sure we're on track and that we're following with compliance. So as you know, earlier this year, it went into effect, the final rule on the salary threshold. It was increased to $35,568 per year, and the highly compensated was also increased by about $7,500. So you see in the slides, it will show you your yearly minimum as well as your weekly minimum. The important part, I thought to point this out because it's already in effect, you should already be in compliance, is that next slide that talks about the 10%. You are allowed to use non-discretionary bonuses, commissions, and incentive payments that are paid at least annually to satisfy up to 10% of that salary level. So if you note that any of your employees are not where they should be for some reason or another, you can correct that by some sort of up to 10%. Through some sort of end of year bonus or something like that. So it may be the time to make sure you're reviewing and double checking all of your salary thresholds. And remember, there's not going to be any increases automatically with this law. We have these new numbers and they will be in place for some time, so you don't have to keep track of them. To the extent there is new legislation on increasing it, we all will hear about it because, as you know, this law took this rule took quite some time with a lot of appeals before it went into effect. Connected to the overtime rule, that salary threshold for becoming an exempt employee, then you look at the others. Those are actually the non-exempt employees that are paid the regular rate. It was important to note that this rule, just like the other salary thresholds, had not been revisited and revised for quite some time. So effective also in January, 15 days later, January 15th of 2020, there was also certain exclusions. It clarified exclusions that would not be part of the regular rate of pay. And I think the exclusions are important so that you know that you don't have to include them, but I think that it serves as a good test and a good time to audit to make sure that you are including everything you do need to include. So although the new rule didn't talk about the inclusions, it allowed these exclusions, which may help a lot of employers. We also have to make sure that the regular rate may change from week to week because of the things that you should be including. And I find that that's probably the biggest infraction for employers, is forgetting to include a non-routine payment in the regular rate of pay for a particular work week. They forget to add something back in for just that week if that person worked overtime or that pay period. So that's important to know. But the slides, I won't go through all the exclusions. They're there for you, and it's been in effect now for now 10 months. So then let's look at the US DOL's proposed new FLSA independent contractor test. I feel like Lori and I have been talking about independent contractor tests for years as well. Things keep changing. Each new administration, things change with a lot of these agencies, as you know, as Lori just talked about, the NLRB changes because of the makeup of the board. And I believe that, you know, all these agencies are impacted by the political realities as well. And so now we're looking at a proposal about the economic reality test to examine independent contractors. Some of the articles made it seem as this would make it easier for employers to designate employees as independent contractors. I still think, though, that because this is just one of many tests, depending on the law you're examining, and there's certain other laws that have a more stringent test, that I would be more conservative in making sure that you really have a sound analysis of whether or not your independent contractor is truly an independent contractor. And you should test that analysis against a few of the tests. So this is just a proposed rule at this time, focusing on two core factors that you saw in that first slide, the control and the opportunity for profit or loss. But then in the next slide, it talks about three other factors that can serve as guideposts. I like the one, and I ask this question often of clients, is whether work is part of an integrated production unit. And I may not ask it direct as that or use those exact words, but the concept is it part of the employer's business? Is it from the start to the finish one of the integral parts of making that product or providing that service? If it is, it's unlikely that person's an independent contractor. Those are the people that come in from time to time or for special projects or for certain issues in the overall business that aren't directly related to that product. So this rule I don't think changes all that much, to be frank, but it is out there for public comment. Then we also get opinion letters. As you know, I think we mentioned it during one of our last term updates, is that the DOL has started issuing opinion letters again. They stopped for some time and they started issuing them. They're very helpful for figuring out how the DOL would interpret a series of facts. And so this is just a reminder about first what the fluctuating work week method of calculating overtime is, and then a few nuanced clarifications. But I thought this is important to know and make sure employers are aware that you can use a fluctuating work week method. They're still supporting it, obviously, through this opinion letter. The fact that they chose to highlight this particular issue, I think, says something. But this is when an employee's hours vary and they are getting paid a fixed salary, even though they're not exempt. They're paying a salary for all the hours they work because it's varying. Some weeks it could be 38, 42, 45, and it's changing all the time. And so they get a fixed salary whether they work less or more. And so under this method, you still have to pay overtime, but you only pay the half-time differential. You don't pay 1.5 times the regular rate for the hours over 40. You divide the salary by the number of hours worked that week, and then you just give the half-time rate for each hour worked over 40. Because in a sense, they've already been paid for the hour itself as part of their agreement with you on a salary basis. But this is not something that is can come back and forth, that you change, you set up for a particular week. This is an ongoing weekly rate based on someone that every week varies. You know, yes, 2 weeks in a row may be the same, but overall you would be able to see a fluctuating work week, and that you have this agreement in writing. So those are some important. This is not for every person that may work overtime from time to time. This is for a unique set of employees, but it can help on budgeting those expenses by taking into account the amount of money at the onset. So in this particular case, the question was, does the employee always have to work above and below to be fluctuating? And basically the answer is no. It can vary both above and below the 40 hours threshold. It can always be appropriate even if the employee is always more than 40 hours work week. The point here is just that the hours fluctuate from week to week. So that is a good opinion letter. As you saw, it was issued in August 31st. If you want to go and take a look at more details, if that may help you and apply to issues you're facing. So with that, I'm going to turn it over to the last topic, to Lori. And at the end, I will say goodbye and we'll open it up to questions. Okay, thank you.
Okay, really quick, guys. There has been some recent and proposed legislation under federal and Delaware law. I'll take you through federal first. The Pregnant Workers Fairness Act overwhelmingly has passed the U.S. House. It's unclear whether this is going to actually have any traction in the Senate, but more than half Republicans joined all of the Democrats, and this has also been blessed by the U.S. Chamber of Commerce. This is very similar to Delaware's Pregnant Workers Fairness Act, basically requiring all employers to make reasonable accommodations for no limitations related to pregnancy, childbirth, or related medical conditions. It also forbids making hiring or other employment decisions based on the need for an accommodation, prohibits retaliation for those seeking an accommodation, very similar to Delaware's law that's already out there. So we'll have to see what happens with this law and whether it becomes the law of the land everywhere. Specifically as it relates to Delaware law, we have two things to discuss. The first one is under the Crown Act. And I wanted to provide some statistics that were actually part of the legislation in Delaware. And I believe the statistics are from Dove, the soap company. So a 2019 study found the following: Black women are 80% more likely to change their natural hair to meet social norms or expectations at work. Black women are 50% more likely to be sent home or know of another Black woman sent home from work because of their hair. Black women are 30% more likely to be made aware of a formal workplace appearance policy. So there have been advocacy organizations and lawmakers around the country that have come together for this broadly known act, Crown Act. Such laws prohibit discrimination in the workplace based on hair, including natural hair, the styles such as braids, afros, curls, twists, dreadlocks. And this is kind of across the country. It's popping up in different states, more than 20 states actually, including Delaware. So Delaware's act is Senate Bill 192. Delaware law prohibits discrimination on the basis of race in a variety of settings. We know that, right? This new law, potentially, because it has not been passed, makes clear that race also includes traits historically associated with race, including hair texture and protective hairstyles, which includes braids, locks, and twists. What's interesting about this law is that if it passes, it's not only going to impact employment, it's going to impact 31 sections of the Delaware Code that protect against race discrimination. And that includes equal accommodations, fair housing, jury selection, hate crimes, education, and employment practices. This was introduced in January, and I'm told that it could have some traction. And so we'll see if it gets reintroduced and where it goes from here. The last one, House Bill 353, unemployment claims. This is now law. This has passed. It ensures that employers are not charged for unemployment benefits of employees that they had to let go, terminate, furlough, or lay off due to COVID. the Department of Labor's intention was to use other sources of federal funds to repay the trust fund. The hope is that they don't increase taxes on the employers. This passed the House and Senate and was signed into law in August. And finally, just a quick reminder about HB 360. We should all be familiar with this. We should have all probably already done our training. This was signed into law in August of 2018, effective January 1. It broadens protections for sexual harassment for all of our workers. It applies to employers with 4 or more employees, but that mandatory training piece is 50 or more employees. Importantly, if you trained your employees in 2019, you're due again for training in 2021. I think that's so interesting because at this point when we're all working remotely, I wonder if the legislature is going to do something to kind of extend that or say, you know, you can certainly do this remotely. So it'll be interesting what happens with that. As a reminder, employers, you have an affirmative defense under this law if you can demonstrate efforts to promptly prevent and correct harassment, and you can prove that the employee failed to take advantage of those efforts. Okay. Here is the Department of Labor notice that must go out to your employees. And questions.
Yes, we do have 2 questions if I can ask these of you. Someone asked, can you please review the new NLRB rules on employees utilizing employers' email? Did you cover that already? Can you?
Using their work email that they can use it.
Okay.
But I'm sorry. You can prohibit your employees from using your IT systems, your IT resources for their non-business use.
Okay. And then the other question.
Can I add one
ahead.
piece to that? You can prohibit, but just generally when you prohibit, you have to make sure you're not just prohibiting for certain things like union organization, because then you're going to get bitten by that. If you prevent it for personal reasons, and you have to do that across the board, otherwise you're going to run into problems.
And
okay.
one other highlight of that, they did say, of course, they left a little bit out there. There could be certain situations where email is the only means of communication. And in those situations, so I'm not sure whether it's maybe a remote workforce, maybe when you're not able to do face-to-face, maybe when your employees are all over the country or something, where it may be reasonable to allow your employees to communicate via email.
Okay. And I'm not sure when you were speaking about this came from one of our viewers regarding fluctuating hours. I believe, Jennifer, you were speaking during that time. Is there a time frame for which that has to happen? 3 months, 9 months, 1 year of employment? When would this apply? Can you recall that?
So this is an agreement that you make before that person actually starts working. So it's some of our statutes have look back periods where you look at an average. This is what they will look back at when they do an investigation, but you as the employer are anticipating a fluctuating work week method. You go into the agreement with the employer that, listen, the nature of our business, some weeks I need you 20 hours, some weeks I need you 60 hours. I just never know. It ebbs and flows so much as my anticipation. I'm going to pay you a set salary for all hours worked. I'm never going to deduct anything. I'm not allowed to deduct in a fluctuating work week. You're going to get that salary whether you work 1 hour or 100 hours. And then
right.
After 40, I will make up the difference. But it's a look forward. I mean, it's a plan in the future. If you realize that you're not having the fluctuating work week, you know, I would think at the 6-week mark, 12-week mark, you really are best served. I wouldn't even probably go 12 weeks out to make sure you switch back to just pay by the hour, because you may have problems.
Okay. And our final question, does the non-discrimination based on hairstyle also include the use of wigs?
I don't believe so. That's interesting. I would not think so, but I don't know for sure. It didn't specifically say wigs. So it's the natural hair, it's the afros, it's the twists, it's the braids.
Right.
I'm not sure that a wig would fall into that.
Okay.
But
okay.
interesting, the wig though could, if it's because of, you know, maybe cancer treatments or a medical issue or something, think about whether the wig can come through for disability protection.
Mm.
Mm-hmm. Okay, very good.
Maybe you could also bring it in as age discrimination. You know, you're losing your hair and someone brings it in from that way.
Yeah.
So I'm very careful with any teasing, harassing based on someone wearing, you know, a wig or anything similar, anything regarding any potential medical issue, any change in someone over time because of age, anything related to that, I'd be very careful, regardless of whether there's a specific act on it or not.
Correct.
Be nice to everyone.
Yeah, be nice. Play good. All right. Thank you so much, Lori and Jen. We appreciate you being a part of our webinar. We always look forward to hearing from you. As you can see on the last slide, it does have information about your credits for SHRM and also HRCI. And lastly, please register for our upcoming annual conference, the 20th annual conference, November 2nd through the 4th. And of course, it'll be virtual this year. So we look forward to seeing you then. Thank you, everyone, and enjoy the rest of your day.
Thank you for this opportunity.
Thank you.
Thank you, SHRM.
Thank you,
Emma, for organizing. We're always happy to be a part of it. Bye.
Thank you.
Thanks.
Bye-bye. Have a good day.